Good afternoon, everybody. I think we're going to get rolling with today's webinar around HHS accessibility regulations. So we will get started and I'll kind of go through some housekeeping in a few minutes here, but I always like to do some quick introductions. So with that, I will turn it over to my partner in crime, Aaron Page, AP, as I refer to you as. I'll let you give an introduction to yourself, and then I'll give a brief introduction and we will jump right in.
Awesome. Thanks, Ryan. And hi, everybody. Thanks for joining us this afternoon to talk about the new HHS rule that was recently released. As Ryan said, my name is Aaron Page. I am Director of Accessibility here at Alliant. I wear a handful of different hats. I help oversee our digital audit teams, our teams that audit websites, mobile applications, that type of thing, to ensure our processes remain aligned with the Web Content Accessibility Guidelines. I head up our accessibility claims team, our team of auditors who are trying to help clients respond in the event they're targeted by an accessibility lawsuit or other demand letter or other legal action. And I get to do a lot of accessibility evangelism work, like what we're doing today, doing webinars, conference presentations, that type of thing. I myself, I happen to be blind. I was born with congenital glaucoma. I lost my remaining functional vision more than 15 years ago now. I've been working in the digital accessibility space for the last 10 plus years, the last 6 of which have actually been with Alliant. So really looking forward to talking with you today about this new rule. It's a great development in the area of accessibility and access to healthcare services for persons with disabilities. So really looking forward to talking with you more about it. Ryan, hand it back to you.
Yeah, thank you, AP. And brief introduction into me and my role. So my name is Ryan Wieland. I've been here at Alliant for almost 7 years, so coming up on my 7-year anniversary in this space. My official role is VP of Digital Accessibility Sales, so I get to work with a lot of clients, not only in the healthcare space, but really across the globe on helping understand, what are these various regulations based on the vertical that they live in or the industry that they live in. And then how can Alliant support them from a digital and document accessibility perspective? I am a member of the Disability and Accessibility Leadership Committee, so also, and we'll briefly touch on this today, and obviously can Aaron and I can both dive in deeper based on any questions that anyone has in the audience, but have spent a lot of time working on procurement accessibility as well, which is obviously a big part of this HHS final rule as well. With that, we'll kind of jump in. I always like to, at the start of these, kind of give the purpose, process, payoff, right? Like, why are we all here? And what are some of the goals and objectives of today's webinar? And I think at a high level, the purpose is really just to discuss accessibility and compliance regulations for healthcare organizations with this new HHS regulation. This is fairly new. In fact, I would darn near call it brand new. A lot of healthcare organizations either don't know about it or know very little about it. So we're going to hopefully shed some light on what is this? What is required? What are you all aiming for when it comes to accessibility and specifically digital accessibility, which within these HHS regulations? The process, I think, from Aaron and I's perspective, and I'll rely heavily on AP throughout this, as he is one of the foremost experts in the space on this topic and all things digital accessibility. But it's really to provide a background on how does digital accessibility play into these requirements, and how can teams start to map out meeting these requirements, and some even keys to building a long-term roadmap, because this is long-term, right? This is a regulation that has a time horizon or deadlines, as we'll talk about, but it doesn't go away when that deadline hits. So I think really helping teams understand how can you build out that long-term roadmap, but also get some short-term wins. And that's really the payoff. I think our goal today is not to get in the weeds and make you an expert on this massive regulation that was just posted, and we'll get into a little more of that a few slides from now, but really just give you a broad overview and understanding of what is this final rule, how does it pertain to your organization, and ideally have everyone walk away with some key short-term wins that you can take back to the rest of your team or the rest of your organization and start to drive towards conformance with these regulations. A couple FAQs. I always like to go through some FAQs and some common things that we get within these webinars, just so that everyone's kind of clear on how we can help or how we can respond to next steps. As I kind of alluded to, and AP, I'll hand it to you in a second, I think one of the big goals is, like, you don't need to feel like, and your goal shouldn't be from this webinar to leave an expert. This is a really complex regulation. There is a lot of pieces and parts to this, and you're going to have to work with a lot of team members, especially at large organizations, to meet these standards. And it doesn't happen tomorrow. Aaron, anything to add to that? I think it's one of the biggest accessibility myths. Everyone tries to solve accessibility tomorrow or do it really quickly. And that's great, right? That's one of our goals in helping organizations is to help make it seamless and efficient, but it does take time, and you've kind of lived on the other side of this. So any thoughts on that topic?
No, I would agree with everything you said. I always like to say that accessibility is a journey. It's not a destination. You're not going to be able to flip a switch and make your website accessible, make your mobile documents accessible, your electronic documents, anything really, your processes, procedures, you name it. Making these things more accessible, and I say more accessible because again, it's a journey, not a destination. There is no such thing as kind of perfect accessibility to everybody. It takes time. And so one of the great things, and we'll talk more about timelines later on, is they were very thoughtful about this in the rule and have really given organizations the time that they're going to need to if they utilize it well to really get things in place for this and to meet these requirements. And we'll talk more about that in a bit.
Yeah, no, that's perfect. I think that analogy is so good, right? It is a journey for sure. A couple other really quick things. The recording will be available on our website, I would say within the next few days. So if you have to jump early because you have another meeting, don't worry, we will get you the recording. And then also you can feel free to share with other team members. If you're watching this recording, sort of not attending live, obviously, again, feel free to share with others and use this as a reference going forward. The final thing is, feel free to drop any questions in the chat. We will do our best to answer a few questions live. I'll also, be monitoring it with the team. So if there's anything I can just answer or we can answer sort of live via text, we'll do it there as well. But our promise to you is if we don't get to your question within the next handful of days, we will respond via email as well. So we'll provide an answer to any and all questions that we get, or obviously if any questions come up after the fact, as you share this with teams or discuss it internally. On the last slide, we'll kind of give you some information on how to reach out to us. With that, we'll kind of jump into the core of the webinar. And I think a background, oh, my slide deck jumped too far. I think a good starting point is really just the history of this landmark final rule, right? And I think one of the biggest things that I'll start off with is this is a part 84, an update to section 504 of the Rehabilitation Act of 1973. And I'll make the most obvious statement that you'll hear today. In 1973, for sure, digital accessibility didn't exist. We didn't have mobile devices and applications and connective, devices to all the digital world like we have today, right? So this is, I would say, kind of an overdue rule and regulation presented by the Department of Health and Human Services, so HHS. And really the goal of this regulation was to ultimately, as I kind of alluded to, the fact that the Rehabilitation Act came out in 1973 to modernize and strengthen Section 504 of that Rehabilitation Act. There was a notice of proposed rulemaking and public comment period back in September of 2023. And AP, obviously, you and one other team member on our side spent a lot of time digging through that notice of proposed rulemaking and responding from an aligned perspective, really to try to help us as thought leaders in the space drive this forward. And I'd love to turn it to you to kind of talk about what that process was like and sort of what that entailed from our perspective or your perspective.
Yeah, absolutely. Yeah, it was great to have the opportunity to submit feedback to the notice of proposed rulemaking. It was even more amazing to actually get the opportunity to read some of the responses that the department provided in response to the feedback that Alliant and other organizations provided to the notice of proposed rulemaking as well. One thing I will point out, if you happen to attend or heard about, or if you attended our recent webinar or have heard about the recent rule that was released by the Department of Justice pertaining to Title II entities. There is a huge intersection between that recent rule that was released by the Department of Justice specifically for Title II entities and this new rule that was released by the Department of Health and Human Services specifically for under Section 504. The requirements that are outlined pertaining to websites, mobile applications, electronic documents, kiosk accessibility, that type of thing, are largely the same. And actually, we had the opportunity to respond to both of these rules when they were in the notice of proposed rulemaking stage. And largely, the feedback that we at Alliant provided was the same between the two. And we primarily focused on the requirements that it outlines pertaining to websites, mobile applications, electronic documents. But it's really important to know, and we'll talk a little bit kind of more about this, I think, in the next slide, that especially when it comes to this HHS rule, it goes well beyond just websites, mobile applications, electronic documents, that type of thing. But just some examples of feedback that we provided at Alliance to this was in regards to the version of the Web Content Accessibility Guidelines that this new rule cites. We also provided feedback around the definition of what constitutes a conventional electronic document. At Alliant, we're an industry leader when it comes to document accessibility and remediation services via our Common Look group. And they had a lot to say about the definition of what constitutes a conventional electronic document. And so we had the opportunity to provide that feedback on both the Department of Justice and the Health and Human Services notices of proposed rulemaking. And as I said, we got the opportunity. You can even go and see if you go pull up these rules on the Federal Register where they respond to the bits of commentary that they received. And some of the comments are directly in response to the feedback that we've provided here. So really amazing to be able to see. The notice of proposed rulemaking was back in September. The final rule itself was actually signed off on back in May. And so it's important to know that the rule itself will go into effect 60 days after the rule has officially been published in the Federal Register. And that occurred on May 8th. So 60 days after the rule has gone into the Federal Register is when it will officially go into effect. And then the additional timelines that we'll talk more about pertaining to when you have to conform your web content, that type of thing, those come into effect starting after those 60 days, so starting in July. So that's kind of the history and timeline of the notice of proposed rulemaking and how it went from being that proposed rule to the finalized rule that you see now here today.
I think that's super helpful, AP. Just kind of that background on the fact that, even, from the government's perspective, they don't just write these up and sort of sign it into law, right? There is sort of that proposed rulemaking period, which I think is really helpful, really gathering and gaining insight from both the community and experts, really across the country. And so that was great that we were able to provide some of that feedback. You kind of noted one thing that I was going to cover off on, which is fantastic, that the final rule was published on May 1st, 2024. And I think the reason I want to call that out is I've had a number of conversations with healthcare organizations really in the last 30 days, in sort of, I would say, response to this, but also not in response to this. And the reason I bring that up is I think there is still some confusion on whether this is just a suggestion or if this is actually a regulation. So I think we'll kind of cut through some of those myths. And one thing is, as you alluded to, Aaron, this has been signed in, right? So this is a final rule. And we'll kind of go through timelines and dates in a few slides here. But that's one thing I wanted to call out, right? I think there's a lot of confusion still on the fact that this isn't just a recommendation. This is a final rule that healthcare organizations will have to comply to. The final thing I'll say is our marketing team did a really fantastic job of kind of populating some of the key links that I think can help teams or internal champions drive out awareness on this. And so if you go to alliant.com/HHS, we have some of the key links like to that final register posting of the actual rule and regulations, as well as a fact sheet that the HHS team put out. So a lot of great information on that page that can kind of conglomerate those key links that your team can share internally. So with that, I think we'll start to jump into one of the key things about this final rule that Aaron kind of alluded to in the last slide, which I think is really important, right? And that is, what's covered in this final rule. In the reality is, this is, if you have had a chance to check out the final PDF of the rule, I actually looked at it earlier this week to see what the numbers were, right, for this webinar. And it's actually a 130-page PDF. And one thing I want to highlight is digital accessibility, so web and mobile accessibility, which we'll really drive into today, is covered on a very small section on page 128, right? So I just wanted to call that out in the sense that, again, when we go back to one of those earlier slides, if you don't have to leave an expert, right? This is really just to give you sort of awareness of what this entails. And I think one of the biggest things is web and mobile accessibility is part of a much broader document and final rule on, that section 504 regulations. And with that, I think teams are really going to have to understand and collaborate on this, right? This covers medical treatment, value assessment methods, child welfare programs and activities, accessible medical equipment, right? So we get into the physical side of accessibility. And then, as I alluded to, web and mobile accessibility is kind of hidden in this very large regulation. And I think that's one of the reasons why it's kind of been missed by digital design development teams in the sense of how does this apply to you? AP, I'd love to turn it to you and kind of discuss the broader regulations and really, from your perspective and lived experience, the barriers that people with disabilities face in the healthcare setting before we even dive into digital accessibility, right? Because obviously this has very strong impact on someone like you and the broader disability community. So I'd love for you to kind of talk through maybe some experiences that you've had in healthcare.
Yeah, it's pretty remarkable, as you said. Our focus, obviously, at Alliant is so much around digital accessibility and electronic documents and making sure that your communications are accessible. And that's a very important part of this rule. But as you said, it's such a small part of the overall rule. There's so much more, and it's important to note that while just like with the DOJ Title II rule, oftentimes when people are talking about it, they often will say it's for state and local governments. Well, yes, it is, but it's also for so much more. It's for anybody who is considered an organization under Title II, right? And this rule, while yes, we use the terms like healthcare, and obviously it has a very health-centric focus. It's not just healthcare and healthcare providers. It's any type of social service provider, any organization that receives federal funding through the Department of Health and Human Services. This rule applies to, and it covers a wide range of topics that impact persons with disabilities beyond just, can they access your website? Can they log into your patient portal? Can they book an appointment with you using your online scheduling tool? Those are all super duper important, but they all comprise just that one section of the overall rule. And then you have other sections that cover really detailed healthcare specific related topics, such as prohibiting providers from prescribing specific treatments to persons with disabilities that they wouldn't prescribe to somebody else, right? It's an extreme example, but one of the examples that they provide in there are providers prescribing sterilization or specific reproductive medications to persons with disabilities. They have examples of organ transplants. The rule includes requirements that prevent discrimination in organ transplant list. So you basically cannot say somebody with a disability can't join the transplant list. Value assessments. Ryan mentioned value assessments earlier, essentially saying that you can't use the fact that somebody has a disability to put a lower value on their quality of life, or essentially imply that by having a disability, you have a lower quality of life, or that your life is not worth living, right? It sounds very dramatic, but this is actually included in the rule. So it's quite broad, it's quite all-encompassing. It covers a wide range of forms of discrimination that persons with disabilities encounter, not just with their websites, their mobile apps, getting access to documents, but actually where do they get the treatments? What types of treatments are they being provided? Can they actually speak up for themselves in terms of what treatments that they are being provided? Just a huge array of topics specifically related to disability rights in the healthcare sector.
Yeah, no, I think that's a fantastic overview, AP. And I think one of the things, and I think we talk about this a lot in webinars or just with clients in consulting scenarios of accessibility takes an army. And that's really when we're talking about digital accessibility alone, right? I think complying with this HHS regulation is absolutely going to take an army, right? I think this bridges the intersection of design and development teams, digital teams, legal, compliance, risk, patient experiences. I think it covers such a broad realm. And I think that kind of tees up into some of the stuff we'll talk about related to digital accessibility and not waiting, right? I think it's important that teams just sort of have this on their radar and start to build out that plan, because this is absolutely going to take time in the broader regulation of this final rule. With that, I do think it's important for us to cover, and you started to allude on this a little bit, Aaron, in the last slide, is who needs to comply with this final rule? Because I do think this is another area where there's some confusion, right? And it really outlines, as I'm sure you'll get into a little bit more, AP, like healthcare organizations receiving federal financial assistance, right? So there is the recent DOJ ruling that's really aimed at Title II organizations, which some healthcare entities would fall into. This HHS ruling really goes above and beyond that, right? Covering, really certainly anyone who receives Medicare or accepts Medicaid or Medicare, anyone who accepts grants. I think one of the things when I was reading through it that was interesting is, even thinking about teams that receive research funding, right? So you get into the edu space in education or higher education providers that have an appended hospital or healthcare entity to that, receiving funding for those things or subsidies. It really covers a really broad spectrum of financial assistance. This is hospitals, clinics and healthcare centers, long-term care facilities, mental health treatment centers, obviously telehealth providers, right? And I think that's one thing that AP, I'd love you to go into, because I think, we feel like it was ages ago. It really wasn't. But I think one of the things in our space specifically, right, being so close to digital accessibility, COVID was certainly very interesting in the sense that all of a sudden, specifically high risk individuals had to access everything through a digital footprint, right? Whether even that was as simple as something like a vaccine registration or telehealth just booming overnight. And I think one of the great things about this HHS regulation is I do think it's really going to drive forward digital accessibility, because I think some of that has legs. I don't know if you want to talk about, even from your experience or just expertise in the space, AP, how COVID sort of drove this digital first healthcare environment and how these regulations are so needed to kind of help people catch up, if that makes sense.
Yeah, no, it's a fantastic point. The silver linings, right, in some things, right? COVID obviously was a terrible public health event, but I will say, as somebody with a disability, somebody who is blind, like that, some of the things that came out of it have been somewhat beneficial to me, right? For example, grocery delivery, right? Grocery delivery was something that was so difficult to do as a person with a disability prior to the onset of COVID. And now I have multiple options available to me to have groceries delivered at not a ridiculously marked up excessive cost, right? Telehealth is another one, right? Being able to actually just have a doctor's appointment remotely without having to go through the hassle of traveling, booking transportation, or taking public transit to get down to the doctor's office, right? If I'm not getting a shot or anything like that, why go through all of that additional hassle, right? And so that is absolutely a kind of great example of the changes that resulted from COVID, and how it did have at least in some regard some positive benefits for persons with disabilities when it came to this type of thing. However, many of these tools also aren't particularly accessible, right? I think about just within the last couple of weeks, I had to log into my primary care provider's portal to review lab results. I needed to go and pay my bill online, and I needed to book my next follow-up appointment with them. And every one of those three things used a different online service, right? And each had varying degrees of accessibility. I didn't have any trouble logging in and viewing my lab results. I couldn't figure out at all how to book an appointment online. Paying the bill was kind of a mixed bag because the process was accessible, but it required me to get a code number that was mailed to me on a piece of paper that I couldn't actually read, right? So, the accessibility of these solutions can vary so dramatically that you just never know. And it's great to see that in this new rule has ensured that all of these types of services, whether they are coming from a third party or not, they are all part of the organization or the providers providing that healthcare experience, and they are covered by this rule. You can't essentially delegate away your accessibility mandate here. If you are using these tools to provide online booking, online bill payment, that type of thing, they have to be accessible under this rule.
Yeah, no, I think that's like I think the personal experience and like the how drastic that process is, right? For like logging into three different systems and then accessing, a paper form to actually get your access API. I think that's such a great example, especially when we get into like the next slide and driving into timelines, right? Because I think the timelines are very important, but I think this is also where we can talk about timelines, maybe seeming like you have more time than a lot of organizations think. So a few key dates within this final ruling. The first one, as AP kind of alluded to earlier, this was actually posted into the Federal Register on May 9th of this year. So the rule goes into effect as a regulation 60 days after that. So that date ends up being July 8th. So just in a couple weeks from when we're doing this webinar, these regulations will basically be formalized. Within that, breaking down the regulation timeline to comply when we think about mobile and web accessibility and obviously document accessibility, and we'll talk about how that plays into the broader regulations as we go through this presentation. But those days are essentially 2 years after for organizations that have north of 15 employees. So if you have 15 or more employees, the final rule states you have to be WCAG 2.1 AA conformant on May 11th of 2026. One thing I really appreciate is, for smaller organizations, so if you have less than 15 employees, there was an extra year provided. So May 10th, 2027. With that, one thing, AP, I'd like you to kind of go through two things from your expertise and your perspective. And I think the first one is carve outs for small organizations. Did we respond to any of that, or was that updated in the notice of proposed rulemaking? I think that'd be interesting because I know there was a lot of sort of pushback on this and timelines being associated.
There was, yes, there definitely was. And if you go and review the commentary that was provided, the feedback on the Federal Register, they talk specifically about the requirements pertaining to small providers. And this was, I would say, an area of some debate and contention in the feedback that was provided. Many felt that, for a small provider with less than 15 employees, being able to meet these conformance requirements could be a pretty significant burden. But in the end, in the final rule that was published, they did maintain the requirement for small providers, so those providers less than 15 employees. However, they granted an additional year of time. So as Ryan, you said, if you have 15 or more employees, then you have 2 years to ensure that your websites, your mobile applications, your electronic documents, your kiosks, that those are in fact accessible in WCAG 2.1 conformant. If you're a small provider, you fit into that definition of you have less than 15, then you will have 3 years. And one thing that I think is important to point out, especially when you are talking about third-party services, is that you're not the only one using these tools, right? You're not the only one who's got this requirement now. And so there's going to be a large push, even among these third-party vendors. They're going to be hearing from many of their clients and hopefully getting the ball rolling on making these services accessible. But in the end, there will be some onus on the individual providers themselves. You'll have to make changes to your individual websites, right? You will have to ensure that your individual electronic documents are conformant, different types of things like that. But at least for you small providers, you have an extra year to do it.
Yeah, that's super helpful, AP. And I think the other thing that I wanted to talk about here, because I think, like, look, I get it, right? Human nature is to procrastinate, and that's just reality for all of us. And I think sometimes we can look at these deadlines, and it's like, well, I have 2 years to comply. I think one thing that we talk about with a lot of large organizations, and I think it's super applicable to this HHS regulation, is like specifically for some of these complex projects. Like maybe if you have a really simple landing page or brochure site, that might not take a significant amount of time to get into pretty strong conformance. But when we start to talk about complex systems, large mobile applications or web applications, I mean, these things, as we've seen, because we've worked with thousands of clients directly, this can take over a year to get into conformance, right? So, like, I'd love for you to kind of dive in from your expertise, both internally here at Alliant and then externally when you were sort of driving accessibility externally. Like this takes time, right? And I think that's one of the biggest. I hope that's one of the biggest key takeaways for organizations that are listening to this is like, you still have a lot of time now, but if you wait 12 months, it's going to be very hard to get some of these things into conformance by those deadlines.
Yeah, no, I completely agree. There are certainly actions and things that can often be done in the short term, right? As you said, if you have just a landing page or a simple brochure site, right? Getting an audit and performing the remediation on something like that, may not take, more than 6, 12 months, something like that. getting your electronic documents, right? Identifying some of your electronic documents and getting those remediated might not necessarily take something like a full 2 years to get done. But on the other hand, if you have an integration with a third-party electronic medical record system, and they're the ones who are providing the patient portal for your patients to be able to log into to access their medical information, that's an extraordinarily complex system that you very likely have limited control over actually fixing the accessibility issues on, right? And so it's imperative to get the conversation started right now with those types of regarding those types of tools and services, because if you have to lean on the third party vendor in order to get those issues fixed, or say you even have to wait until a contract renewal comes up in order to include new language mandating that that vendor make their system accessible, that's something that you'll need to start on quite soon. And so absolutely, there are some things that can be done in kind of the short to near term, but when you think about the scope, especially of your billing systems, your record keeping systems, electronic medical records, online appointment booking, types of systems like that, those extraordinarily complex systems can really take a long time to make those accessible.
Yeah, I think that's great feedback, AP. And I think the final thing that that I kind of want to talk about here when we think about the broader timelines is the compounding effect, right? Like, so you take your digital properties today as they sit or as they are, and you have 2 years to build into conformance, right? I think the challenge for a lot of organizations when we start to think of, the fact that 2 years will fly by is the fact of maybe they're releasing an update tomorrow, next week. Maybe they're deploying something totally net new or designing something net new 3 months from now, right? And I think the downstream impact of not baking in accessibility now, all of a sudden, if that takes 3 or 6 months to get deployed, you're down to a year and a half, and you've now built something and deployed something that you have to go back and fix. So I think, it almost, and it's a strong statement, but in some ways, AP, it kind of doubles the cost impact, right? And the resource impact. So I think that's where I like to talk about, starting to upskill your team today and leverage that 2 years instead of waiting and building a lot of inaccessible stuff and then trying to go back and fix all of that. So I don't know if you have any additional thoughts on that, but I think there's a lot of time for teams to upskill their teams and start to build this in proactively versus having to sprint to the finish line if they wait till the last minute.
Right. I mean, it makes me think about training and design reviews in particular, right? As you said, upskilling the team, training your developers on here's how you make basic web pages and web content accessible. Here's how you label controls. Here's how you define relationships, different types of really kind of basic accessibility 101 for those development teams. That way, if you're rolling out a new website or a new homepage, a new platform in 3 to 6 months, those learnings can be incorporated into that, right? Or a design review. If you're building out a new website that you're planning to roll out in 6 months, let's evaluate the wireframes of that, right? You can identify many accessibility issues early on and potentially just avoid them entirely by applying simpler overall designs, right? Using a simple nav menu instead of a mega menu, using a simple autocomplete rather than kind of more complex autocomplete functionality that's tied into cards, other types of things like that. Many of the more complex accessibility issues can really be headed off by thoughtful consideration during the design process. And so I would almost even say so much the better, Ryan. Like in the example you said, if you're rolling out a new site in 3 to 6 months, that gives you an opportunity actually to really start baking into the accessibility of that right now before it even gets deployed.
Yeah, 100% agree. That's such a great point. I think that, again, don't make this harder on yourself, right? Like you have time to proactively do it today, and it will ultimately save you time, energy, resources downstream. We did get a really good question, AP, that was fed directly to me just now, and that was, I'm trying to find it on my other screen. Are there fines for non-conformance with these requirements or deadlines? And we can kind of ping pong ball this one back and forth, AP. I have read the 130-page document a few times, actually, because I think the comments are quite fascinating, that the fact that they put all of those comments in the final ruling, and there's a lot of helpful information in there. My understanding is there are not fines associated or called out directly in the final rule. I think this kind of defers back to Title II, and I've actually deferred to a lot of, because we never like to give legal advice, and I'm certainly not a lawyer. There's a lot of really good legal content out there that's been posted by firms that work in the healthcare space a lot, and the way that I've read it from them is there's actually pretty substantial fines associated with this and nonconformance, and that is a $75,000 fine for the first claim of nonconformance, and then a $150,000 per non-conformance claim or fine after that. So those are not small numbers. AP, anything to add to that? Because I don't want to misspeak on any of that. I don't think it's in the actual final rule, but I think it defers back to, I think, some of the 504 and Title II stuff.
Yep, that's my understanding of it as well. In my reading of it, in both the NPRM and in the final rule, they don't specifically state here is a dollar amount that you will be subject to if you fail to meet conformance by the particular date. I think, as you said, in the end, it's going to come down to the individual enforcement actions once the rule goes into effect, right? And that's going to be 2 or 3 years from now, and that's when we'll really start seeing what's being charged, and also what constitutes a claim, right? Does every potential violation of WCAG constitute a claim? I mean, if that's the case, these fines could snowball very quickly, right?
Yep.
For a non-conformant website. So I think a lot of that is really to be determined at this point. We're going to have to see, but there's no question that if, when enforcement actions begin around this, there's going to be fines associated with it for sure.
Yeah, no, super, super great insight, AP, and confirming that I didn't miss something in sort of reading the final rule. With that, I'll kind of turn to like, what are the specific digital compliance requirements, right? Because we've talked a little bit about this and in the deadlines. So like, what needs to comply? And I will say, I thought both in the Title II and the DOJ ruling and also this HHS ruling, one thing that was really interesting, but also great for me to see was that mobile apps were included. So really what this covers, it's actually covered in subpart I, is web, mobile, and kiosk accessibility. So web content refers to obviously brochure websites, as AP kind of went through some of this earlier, right? Appointment scheduling, patient portals, all of the like. Also digital documents, and we'll kind of highlight digital documents because we have a lot of healthcare clients on the PDF and digital document side, and a lot of great solutions on that front. And that's, I think, one of the ways that we'll talk about that teams can get some quick wins. I don't want to lose sight of that being included in that, but also mobile applications. And I think this is one where I certainly, I have a young son, and this is one where I've seen a lot of healthcare organizations kind of almost pushing you to mobile applications, whether it's for insurance information or, even pharmacy alerts and stuff like that, getting information to result. Mobile apps are becoming almost integral with the healthcare system. So AP, I don't know if you have anything to add on like mobile being included, but I thought that was a good addition. And then I have one really good question for you on this topic.
No, I think it was fantastic to see that mobile was included. One also item that was included, you didn't make mention of this yet, but I imagine you probably were gonna, is around conventional electronic documents as well, right? So your PDF documents, your PowerPoint slides, your Word documents, your online forms, different types of things like that were also included. I completely agree though about the overall push to mobile applications and the need to ensure that those are in fact accessible. And it's great to see that the standard that was actually selected for this, the Web Content Accessibility Guidelines version 2.1, is a version of WCAG that includes mobile-specific accessibility requirements, right? So they weren't citing an obsolete version of WCAG that didn't include mobile as well.
Yeah, no, super. Yeah, I think that's a good point, right? Because I think there is a lot of confusion in this space, and our team does a really fantastic, our mobile accessibility team, really helping teams understand and bridge that gap between, WCAG, obviously referring to web. So that's a great call out, and just kind of cutting through, I think, some of the confusion on what is the conformance standard for mobile applications. My more pointed question for you, AP, on this slide, where I think you'll give a lot of great insight is, and I get this, I fully understand this is a loaded question, so I'm going to put you on the spot. I know the requirement is WCAG 2.1 AA. I think you have some great insight on, and I'd love to hear from you. Like, would you recommend teams, like if they are building something net new, maybe at least consider 2.2? Like, what are your thoughts on that?
Yeah, no, it's a great point. And I will say one of the bits of feedback that we at Alliant, and I think many others, based on the kind of response that the HHS put out, I think this was a comment that they got from many, many others as well, was around the version of WCAG that was cited in the rule. And in the final version of the rule, they point to WCAG version 2.1 level AA. And those of us in the accessibility field are probably aware that version 2.2 of WCAG came out towards the end of last year. And so I know on behalf of Alliant, one of the bits of feedback we provided was, consider mandating WCAG 2.2 instead of 2.1. Better yet, consider writing the rule in a way that it makes reference to whatever the most current version of WCAG is, right? Don't make it static. Make it so it cites 2.2 now, but when 3.0 comes out in a few years, it will automatically refer to that, right? It defers to the most recent version. And this was something that they actually addressed specifically in their response to the public comment. I thought it was fascinating, great to just kind of understand the reasoning why. And the reasoning that they provided for sticking to 2.1 largely came down to kind of two things. One is that WCAG 2.1, it has been around for a lot longer, right? It's been around since 2018. So there's a lot more experience among accessibility professionals, among web developers. There's a lot more tools and resources available out there to help you conform to WCAG 2.1. Right? WCAG 2.2 is so new that a lot of web devs, a lot of accessibility experts, a lot of tools aren't yet designed to help you conform to WCAG 2.2 yet. And so they didn't want to mandate conformance to a version of WCAG that would be hard to actually conform to in practice. That to me certainly makes sense. They also pointed out that they stuck to 2.1 rather than 2.0, specifically because 2.1 includes requirements specifically for mobile applications, right? And because mobile applications are included in this rule, they wanted the standard to include support for accessibility on native mobile applications. And then the last bit that they mentioned was there is essentially a law. I don't have the name of it in front of me, their exact response, but they're essentially mandated by law that they must cite a specific version. They can't actually frame the rule in such a manner that it would automatically update to reference the latest version of WCAG. They're prevented by law from being able to actually do that. And so they had to pick a version. And so it was either going to be 2.2 or 2.1. And they decided because 2.2 is so new, the tools and resources are not yet out there, they went with 2.1. So really great to understand the kind of reasoning why they did what they did there. Now, to answer your question though, Ryan, about like which version of WCAG should you aim for? I would 1000% encourage anybody and everybody to shoot for WCAG 2.2 conformance. One really great thing about the way that WCAG, the 2.0 versions are designed, is they build upon one another, right? WCAG 2.1 has everything that was in WCAG 2.0 plus more. WCAG 2.2 has everything that was in WCAG 2.1 plus more. Like technically, there was one requirement that was actually removed in WCAG 2.2. That's really getting into the weeds. But generally speaking, these build upon one another. So you can really treat them as milestones, right? Set 2.2 conformance as your goal, right? But then you can have milestones, get to 2.0 to start with. Then you get to 2.1. Then you get to 2.2. They naturally build upon one another. And obviously, depending on the context, you might order this differently. Let's say if it's a native mobile application, you might target 2.1 conformance kind of right out of the gate, right? But they build upon one another, so you can truly treat them as milestones. But if you want to ensure accessibility to the widest range of users as possible, 2.2 is the way to go. And the rule allows you to do that. The rule allows for you to adopt a more rigorous standard. So if, for example, you want to do 2.2, you can do that. If for your conventional electronic PDF documents, you want to adopt, PDF UA or the well-tagged PDF standard, you can choose to do that. It's essentially setting a floor, not a ceiling.
So that's great insight, AP. And I think until you actually walked me through that, I didn't realize sort of why they called out 2.2. And I think there's a lot of confusion and maybe I'll call it frustration, just in full honesty, around why 2.1 was referenced instead of 2.2. So I do think that's amazing intel from your side. The final thing on this slide, I don't know if I know we talked about it a little bit recently. There's, and forgive me if I use the wrong term, there's 5 essentially carve-outs that are not required to conform. I think it's 5. Do you want to briefly touch on that?
Yeah, yep, absolutely. There are 5 exceptions in the final note. I'm sorry, the final published rule. There were 6 actually in the original notice of proposed rulemaking. One of the exceptions was dropped, and so there are 5 exceptions in the final rule. And just kind of hitting on these at a high level. The first one is around archived web content, basically saying that if you have archived web content, and archived is a very loaded word. It has to be clearly labeled as archived content. It has to live in an archived section of the site, a section that specifically says it's a library or it's an archive. It also can't have been updated or changed since the date of it being archived or since the day the rule goes into effect. So that archived web content is exempt. So essentially, if you have a web page with I don't know, investment relations information from 10 years ago, that web page, if it's living in an archived section of the hospital site, then it would not be required to be made accessible under this rule. It would fall into this exemption of archived web content. Um, Pre-existing electronic documents. And so your electronic documents that already have been created before the rule goes into effect, and which are not necessarily used as part of a service. And so uh, this one is a little bit of a hard one to parse, but essentially, if you have an existing electronic document up on your site, it's not, say, a form that's used to apply for a service or anything quite like that. It's just an informational document. Then because it is pre-existing, it does not have to meet the requirements outlined in here until it is updated. Now, if you update that document, then it's no longer considered pre-existing, right? And so once it's been updated, then it falls under the requirement. But if it's not been changed since before it went into effect, and it's not necessarily integral into applying for or utilizing a service, then that pre-existing electronic document would be exempt. Content posted by a third party. And so this is like a super important one to like make the distinction here. Not third party tools or apps or services that an entity or a provider is using, right? That is not what this is talking about. So, in the example I mentioned earlier that I just recently dealt with, where my provider was using a third-party appointment scheduling tool. Well, that third-party appointment scheduling tool, even though it's a third-party tool, it will fall under this rule, right? What this exemption is talking about is content posted to your site by a third party. So let's say maybe the health group hosts an online discussion board, right? Where community members can go on and they can create posts talking about treatments or services, different types of things like that. Well, the posts created by random people who log into the discussion board, those would fall under this exemption. That is not content that is being created by the provider or posted by the provider. That is content that is being created and posted by an independent third party, not on behalf of the provider. And so it falls into that exemption. Now, again, it's really important to kind of distinguish between the third party content and the third party services. So as I mentioned in that example, let's say a hospital or a medical group is running an online discussion board, right? Well, the posts to that discussion board by individual community members, they fall into this exemption. However, the discussion board itself, that is a platform being used by the provider to provide a service. That platform would actually be required to be accessible, right? So this is really just talking about content created and posted by a third party, not on behalf of the provider. Linked content, fairly straightforward here, but basically it just says that if you're linking out to external content, you're not subject to the accessibility of it, right? You're not responsible for it. The gray zone there does come into play if that is part of applying for and using a service, right? So thinking back again to the example that I just recently had, when I needed to go pay that bill, it was not on my healthcare provider's website anymore, right? I was on an external website that I had to enter in the billing code number or whatever it was into. That, even though it is technically a linked third-party site, that was part of their service, so it would not fall into this exemption. On the other hand, let's say, you're a hospital and you have a link on your site to the United Healthcare homepage, right? And you just say, we accept United Healthcare, and we have a link to their site. Well, you're not responsible for the accessibility of the United Healthcare website, right? So that is how that works, that linked content. So not if it's part of a service, providing a service, or if it's a third-party tool that you were utilizing, but if you're just linking to an outside third-party website or resource, that falls into this exemption. And then the last one is individual password protected documents. I will say, as somebody with a disability, this is the one that grinds my gears the most. But essentially what it says is that if a document is being created specifically for one individual, that document doesn't necessarily have to meet these technical standards. So if you are producing a bill for me, and it's just for me, it's not for anybody else, it's information that is specific for me, that PDF of that bill doesn't have to be made accessible. It falls into this individual password protected documents. As long as it pertains to one individual and it's not made public, you have to actually authenticate or log in to access it, then it falls into this exemption. The caveat here is that this is only talking about documents. It's not talking about the platform. So if you have to log in to your portal to see your bill, and then there's also the option to download your bill, yes, technically that downloaded document version of the bill doesn't have to meet this requirement because it is an individual password protected document. However, the platform itself that you logged into, where you can also see the bill information, that does have to be accessible, right? And so this is very specifically just for the electronic documents, just for if they are specific to one individual, and just if they are behind some kind of a password protected environment. So if you sat in on our DOJ Title II webinar not too long ago, these might sound very familiar to you. And the reason for that is these are exactly the same 5 exemptions that are in the recent DOJ rule for those Title II entities as well. They have the same set of exemptions. They work in the same exact way. Really, the only difference is the example that is provided for the individual password protected documents. The example they give for that is a water bill. But the idea and the concept is exactly the same. So you can really see that the HHS and the DOJ sought to create a lot of alignment between these two rules.
Yeah, and I think that's a great point, AP, on the end. And I think going through those is super important and a great use of time, because I think there is some confusion of what maybe is or isn't included. So that's extremely helpful from my perspective. With that, I'll kind of, and we're kind of coming up on, we try to aim for 60 minutes for these. So we'll cover some of these slides fairly quickly, and we promise to give you some potential wins or takeaways that you could leave with. And I know I definitely want AP to dig in a little on the next slide around procurement accessibility. So I would say on this slide, and kind of closing the loop on both the exceptions, but also the timelines, just reiterating, like, starting your journey today, right? And I think so many teams, and one of the biggest challenges that teams have, and this is not healthcare specific, this is really every industry, is trying to hit the finish line so quickly, right? And trying to aim for this full compliance or 100% conformance, which AP and I tell teams all the time, that's really not possible, right? There is no 100% conformance site or application on the internet. And you kind of you need to work to this over time. So I think one of the biggest things leaders and internal champions can do is really get support from others and start to build out check-ins, milestones, realistic milestones. One thing I tell all teams all the time, especially organizations that have multiple websites, multiple applications, hundreds or even thousands of documents, right? Start to build out a digital and document inventory. Identify, who are those key content editors? Who are the owners of those products? Like, really building out that team and identifying, okay, who's going to champion ABC versus XYZ. And I think that's such an easy way to start tangibly impacting accessibility today, and at least put it on everyone's roadmap. With that, we did get one good question in AP. I'll try to cover this quickly before we jump to procurement accessibility, because third parties are such a big impact on this HHS final rule. And that was this is a great question because I think we see this in all industries, not just healthcare. And that question was, we have a number of team members that build and post PDFs on our website and other applications, but none of them are necessarily accessibility experts. What's the best way to manage this? So, as I said, we hear this question and concern, I think, in government, certainly education, both higher ed and K through education, and also healthcare. And I think one of the biggest things that I would just touch on really briefly is, reach out to our team. We have a bunch of amazing digital document experts, and we can kind of walk you through how we can make that simple. And I think that's one of the things I'm going to talk about on the key takeaways of how Alliant can help you hit some of these quick wins, right? Doing that digital document inventory. We have an amazing tool called Common Look Clarity that I'll highlight really briefly a few slides from now that makes your life really easy on that front. And so we do have a lot of amazing software tools, both our flagship Common Look PDF that plugs into Adobe Acrobat Pro and makes building accessible PDFs much more realistic for teams. The Common Look suite of services that plug into Word and PowerPoint, but also remediation services. So we can certainly help with that question. Don't worry, you're not alone. That's one of the most common questions I think we get even in our digital side of the business is, hey, we understand how to drive digital accessibility. Documents are kind of the bane of our existence. So we definitely have a lot of services and softwares that can help, and reach out to our team after the fact, and we'd be happy to do that. With that said, AP, on this slide, I do want to get to this one for sure. Talking about third-party software and how do you build out and control this? Because one thing that was not lost on me in this final rule in that subpart I was, and I have it directly quoted on the slide deck here, is content that's made available directly or through contractual licensing or other arrangements. And I think this is so relevant to healthcare. It could be something as simple as a customer service or website chatbot to your appointment scheduling application that you referenced, AP. I don't know if you want to talk a little bit about, and maybe we can cover two birds with one stone here, talking about our procure insure service, but also the challenges specifically in healthcare. Because look, I've worked directly with a lot of healthcare organizations, and I think a lot of healthcare orgs that are either on here live or listening would agree. Healthcare has really long procurement cycles, right? So you talk about a 6 to 12 month procurement cycle, and you have 22 months essentially from today to comply. That's a challenge, right? So AP, I'll kind of turn it to you on thoughts around how third parties are impacted by this, and then maybe let's cover off on how we can help with one of those key wins in our a 30-second overview, if that's possible, on our amazing procure insure service.
No, it's a fantastic point, and I mean, I've even made reference to multiple examples just throughout the presentation today, right? When I think about my recent experience, I had to deal with 3 third-party tools just to log in and view my lab results, just to book an appointment, and just to pay my bill, right? It's really important in the healthcare industry, but not just healthcare, really. Everybody is impacted by the accessibility of third-party content and solutions and technologies. It is a huge, huge issue. And it's not a simple prospect. It's not as simple as just, well, remember to ask your vendor whether their software is accessible or not, and buy the one that says yes. That's generally not how it works, right? There's a great organization. If you've never heard of Disability In, would highly recommend you check out their website. Ryan is actually a member of the Disability and Advisory Council. They have a fantastic resource they call the Procure Access Toolkit, and it is all about how to go about procuring accessible information and communication technology. What are the questions to ask? What are the documents to request? How to go about conducting your own independent accessibility evaluation? How to include contract language to ensure that these vendors are required to hit accessibility milestones. Just an amazing resource, a lot of fantastic information there on the Disability and Procure Access Toolkit. Ryan, also you mentioned Procure Insure, right? And so one of the key tenets of the Disability and Procure Access Toolkit really is that you can't take them at face value. You can't just simply accept the vendor's word that their software is accessible, or accept their accessibility conformance report, which states it's accessible. The only way to know for sure is to conduct your own live independent assessment of the software by actual users with disabilities. There is no such thing as an automated tool that can be run on a website or a web application or a desktop application that can by itself tell you whether or not that application is accessible or whether or not it discriminates. The only way to know for sure is with live user assessment, and that is one of the core blocks, building blocks of the Disability and Procure Access Toolkit. And it's a real problem, right? Because not every organization has internal accessibility experts, has persons with disabilities who can conduct those kinds of assessments. And so that is where we can actually help out with our Procure Ensure offering. And so what Procure Ensure is it is a free 2 to 3 hour assessment of a piece of software that you can request from Alliant, which we will conduct by our live audit team, including persons with disabilities, right? And so obviously it's not a comprehensive audit. The idea is to see whether or not some of the primary functions of this software, is it actually accessible? Is it actually operable? How bad is it? Truth be told, if the software is really inaccessible, it doesn't tend to take that long to figure that out, right? And so a simple example would be an online appointment booking system, right? We talked about that all throughout this. Well, one of the first Procure Ensure assessments that we actually did, we used Calendly as the example. And what we tested was that flow of the user actually going through and booking an appointment. And our question was, can somebody who is blind, who uses a screen reader, can somebody who uses keyboard only navigation, can they actually do this? Can they use the tool to actually book an appointment, right? You can apply that concept to these other tools that I've talked about. Can a person with a screen reader actually go in and pay their bill? Can they actually log in and view their lab results? This isn't obviously a comprehensive test of all of the functionality, but if that type of simple baseline functionality is not accessible, you can feel pretty confident that the rest of the application is not going to be accessible as well. And that type of assessment doesn't tend to take very long to do. And at the conclusion of it, we provide a color-coded report. It's green, yellow, red. Basically, green means we either found no issues or the issues we found were so minor we don't consider it to be a significant barrier. There is yellow. Yellow means we encountered accessibility issues, but the issues were not so significant as to prevent a user from being able to complete the flow that we were testing. And then a red rating basically means the accessibility issues we found were so severe, we would not expect a screen reader user or keyboard only user would actually be able to complete the flow we tested. And so that's what you get at the conclusion of a Procure Ensure assessment. One last plug I will say about this, something that we are actually working on is kind of an updated version. We've been doing Procure Ensure for about a year now. And this report that I described has kind of been the heart and soul of it. We are actually now in the process of incorporating live demonstrations by our screen reader auditors, because every one of these assessments includes testing by one of our native screen reader auditors, somebody who is blind and actually uses the software on a daily basis. Our intent with the kind of 2.0 version that we are soon to be rolling out will be to include actual demonstration videos demonstrating the accessibility and usability of the software as well. Sorry, Ryan, not quite 30 seconds, but there you go.
That was perfect. And it so perfectly leans into the next slide, AP. And that is, one of the biggest takeaways I hope everyone has from this webinar is, again, like really just an understanding of what's out there, what you're aiming to comply with these milestones and timelines, but then also how to build some of those short-term wins, right? And I think a couple wins that I think are important or could really help teams publicly do this is like post or update a strong web accessibility statement, right? I still see in the healthcare and government space a lot of accessibility statements that still reference 2.0 conformance and update. It could be as simple as updating that from 2.0 to 2.1 and in referencing some procurement stuff like we just did on our website, right? So our Alliant website, we AP just actually worked with our team to update our accessibility statement. So go out there and check it out, right? I think sort of holding yourself publicly accountable for the fact that you're aware of this and you're aiming for it can really help drive teams forward. Another one would be performing accessibility reviews of software or renewals you have upcoming for third-party software in the next 60 days, right? And AP just went through a perfect solution that is no cost. It makes that very easy for you. So reach out to us. We'd be happy to dive deeper into Procure Ensure and how that can be a really easy, short-term, quick win for your team of starting to assess those third parties so you don't get trapped with a third party that's not accessible and leads to ultimately legal risk or fines for your organization that you don't control, right? And I think that's super important. I'll leave one of these, and that is assess your most heavily leveraged PDFs, because I have another great solution for that in a few slides that I'll kind of close with. And the last one would be host an accessibility lunch and learn for key staff members, right? And AP and I actually do these all the time for teams. We'd be happy to set one of these up and schedule a screener or demo, just building that buy-in for organizations. I do want to quickly talk about how Alliant can really help you, simplify and make this path to conformance much easier. We have ultimately the trifecta of accessibility solutions. We have a digital accessibility division. We work a lot on electronic documents. We also have a print accessibility and alternative format team. So we really can help your team, whether it be one service or one competency or all of them. So reach out. We'd be happy to help. And the final thing I will say as it relates to, assessing those top PDFs, because I think PDFs in healthcare are such a challenge because teams don't know even what they have out there. Doing that inventory assessment, we have a really amazing tool called Common Look Clarity that can essentially crawl your entire website or intranets or portals and give you that litmus test of, hey, how many PDFs do we have and what is the conformance level, right? It will shoot out a report that says, hey, you have 500 PDFs and 20% of them are untagged or 80% of them are untagged. It really just depends on how much work you've done, and then runs another test against, as AP kind of alluded to, either PDF UA or WCAG 2.1 AA. So we can really make this easy for you, have that back to you within a few business days, and really help you build out that roadmap and inventory of how accessible are our PDFs and how big of a challenge or undertaking is this, and then have a more informed conversation of how we can support you on that front. So that'd be another quick win. We'd be happy to provide you that clarity report. Reach out to our team. It's a no-cost service that we can kind of help you build that journey, as well as, again, as AP perfectly alluded to, Procure Ensure being a no-cost service as well. With that, AP, anything else you wanted to sort of highlight today? Otherwise, I think this, I think we hit the goals of really helping teams understand what is this, what are they up against, what are those timelines, and then ultimately, we can have deeper and more informed conversations of how Align can help.
Yeah, just one last thing is probably good to hit on. I expect we are probably already getting questions in the chat asking about this. I have my screen reader set not to automatically read out the chat so I can read my notes, but I suspect we are probably getting questions along the lines of, why is Procure Ensure free? Can you explain that just real quick before we wrap up?
That's a great question. And so there's really, I would say we're always transparent of why this is free, right? I think there's two core reasons. One is we're corporate partners of Disability In. We, AP and I talk all the time with Jeff Whistle, who built out Procure Access and leads the Procure Access team over there. And I think Jeff really explains and is a big advocate of Procure Ensure for one main reason, and that's why Procure Access was built as well, right? Like driving this forward, right? There's no software out there, to a point you made earlier, AP, that only one healthcare organization is using. And you know what? It's not just healthcare, right? A lot of the systems and third-party software and applications that healthcare organizations are using and that need to be in conformance with this HHS reg are the same thing that's being used in higher education or even for a Title III, B2C company, quite frankly. So it really helps us push this forward as a leader in the accessibility space, right? We do an assessment that allows that vendor to become more aware and ideally allows them to work with someone like us to get that product into conformance, get those ACR reports, do ongoing testing of those products. That's a perfect segue into the other reason why it's no cost, right, for our clients. And that is, it is a fantastic opportunity for us to have informed conversations and ultimately work with those vendors. We get an opportunity to present them with pitfalls to accessibility where their product is not into conformance. And by way of that, a lot of the organizations that we're actually supporting with Procure Ensure, they essentially recommend them to work with Alliant because we can do that testing, like you said. We can do, that 2 to 3 hour Procure Ensure assessment that AP explained. That's going to cover off on the 100,000-foot view of a complex application. On the flip side, it really should be on that vendor to drive accessibility. So we can work very closely with that vendor through our core digital services, do that live user testing, roadmap for them. What are the highest priority issues that are currently creating access barriers in that platform, and ultimately give them that third-party VPAT or accessibility conformance report that they can then turn back to you guys as their client. So yeah, fantastic question, AP. That's why Procure Ensure is free. It does become, honestly, a lead gen source for us, but also allows us to really push accessibility forward because it's never a one-to-one software client, right? You might be using it, but thousands of others are probably using it as well. So it really pushes forward our mission and vision here at Alliant of scaling accessibility for all organizations across the world. So great question. Did I cover that well?
You sure did. I have nothing more to add to it. Thanks, Ryan.
Awesome. Awesome. No, that's a great question. I appreciate certainly everybody joining today live. Appreciate everybody taking the time to listen to this, whether you checked out the recording or attended live. And if you have any questions at all, the information's on the screen, but also stay at here. You can reach out to us anytime at info@alliant.com. You can visit our website, ALLYANT.com, or call us toll free at 1-800-563-0668. And we'd be happy to dive deeper into this topic or talk about anything accessibility that we could support you on. Thanks all.
Thank you all. Have a great day.